And I figured this is going to be in the round file of these lawyers' offices in about 1 hour. To my utter amazement, and this is not an important part of my remarks, they didn't object to it. Neither side objected to it. So that's the map that was adopted. Now, I hope you get my point. It is that I've had personal involvement because of what I understood to be my constitutional duty in an undertaking that was blatantly political, belonged to the legislature of the state of Michigan, which early on said, we'll never get together, we can't do that. The Dems have control of the House, the Republicans have control of the Senate, we'll just never get it done. And they were, if not happy, satisfied to dump the whole thing in the hands of life-tenured federal judges. That's Exhibit Z of my long litany of reasons for having the opinion that the Supreme Court, which defined that process and imposed it on the lower courts, is out of control. But that isn't the only reason. The justices of the Supreme Court, beginning roughly with those appointed by President Eisenhower, Justices Warren and Brennan. I forgot my watch because Judge Brennan said I should keep this short. Well, I'll just look at that clock. President Eisenhower, who you young people may be happy to learn was a warrior and later a president of the United States, was required to make 2 appointments to the United States Supreme Court pretty close together. He was urged by the Republican activists to appoint California Governor Earl Warren in order to get him out of the presidential race, clearing the path for President Eisenhower, General Eisenhower. And that was a good reason they thought to get rid of Warren politically. And the East Coast politicians, Catholics particularly, we are told, thought it'd be a great idea if the president put William J. Brennan from the New Jersey Supreme Court on the United States Supreme Court, because that would make the Irish and the Catholics happy, and he would represent kind of the East Coast thinking. So he did that. And it would be only you young people who have not heard, because it's really part of the lore, that when the president left office 8 years later, some reporter asked him, "Sir, what do you regard as the single greatest mistake in the course of your presidency?" And he said, "I made 2, and they're both on the United States Supreme Court." That was a beginning, because Justices Warren and Brennan were the beginning of the Supreme Court assuming for itself power light years beyond what was contemplated to be properly assigned to federal judges when Articles 2 and 3 were written. I can't take the time, and I wouldn't insult your intelligence by making an attempt to list all the instances in which the Supreme Court has lost its way. Many of the outcomes are very appealing to some people, but they are not appealing to me as a proper exercise of the federal principle of judicial self-restraint, or the familiar principle of judicial self-restraint. There almost isn't any of it in the federal judiciary, except in individual cases. So beginning with the early Mapp versus Ohio, the case in which the search and seizure laws were made applicable to the state, the justices found themselves making law with regard to voting rights, with regard to housing, with regard to education and employment. In Brown versus the Board of Education, the justices decided that the Constitution forbade the segregated public schools, arguably a proper function for the federal court, but went on to say, and the remedy will be bust the kids all around, which no one until that time, in my reading, thought was a legitimate exercise of the authority of the Supreme Court to apply the 14th Amendment. And the court has decided to apportion state legislatures, and it has decided to lay down rules for lesser lights like myself in the federal judiciary to make apportionment of congressional seats. The court has indicated a consistent and damaging hostility to religion from the very beginning of its first addressing the Establishment Clause and the Free Exercise Clauses of the First Amendment, so that now the court is stuck with a jurisprudence which none of the justices, excluding the 4 new justices, all of the others on the court have expressed opinions in which they've said our jurisprudence on the separation of church and state and the Establishment Clause is confused, inadequate, and needs to be fixed. Well, I agree that it's confused, inadequate, and needs to be fixed, but in my view, not by them. They got it unfixed in the first place. An Article 5 convention might want to take a look at the authority of the Supreme Court and the federal courts to fix, or not to fix, the role of federal courts with respect to the First Amendment religion clauses, because you know there are others. Finally, I would hope an Article 3 convention could take a look at the role of the United States Senate to advise and consent the President's nominations. As you know, the Constitution provides the President, with respect to the Supreme Court and other federal judges and other executive officers, the President shall nominate and then shall appoint with the advice and consent of the Senate such persons as he or she wishes to serve in those offices. In the case of judges, it's a lifetime tenure. It's not so with respect to other executive appointments. The history of the Senate's role, which I have before me and I won't take time to delineate, is one in which from the very beginning the Senate thought the emphasis ought to be on the word advise and not consent. It wasn't thought for the first 100 years of our constitutional life in this country that the Senate were co-appointers. Doesn't say that, and the senators would deny that they take the position that they are co-appointers, but the fact is they think they are. And the fact is that since the Bork debacle, in which we were, by reason of television, privileged to watch the ridiculous performance of Senator Kennedy debating with Professor Bork the doctrine of original understanding, embarrassing dialogue to any law student or law professor who watched it. And later, when Senator Joe Biden was chairman of the Senate Judiciary Committee, excoriating Judge Bork, at the same time excoriating witness Bork during his nomination for not apparently having any understanding or acceptance of the notion of the natural law as a legitimate component of constitutional interpretation. And then 8 years later, telling candidate Clarence Thomas that he had no business considering the natural law as a legitimate component of constitutional interpretation. And it's all, I think, mostly attributable to television, show business. Now, an Article 5 mandatory convention might want to take a look at whether the advice and consent provision of the Constitution needs explication or deletion. Nowhere is it written in the stars or in the natural law that the President can't appoint justices of the Supreme Court without the advice and consent of anybody. It's in the Constitution, but an Article 5 convention could take a look at the wisdom of that based on experience. The Barnum and Bailey show, which attaches to every confirmation hearing of a proposed United States Supreme Court justice, ought to embarrass all of us who have any sense of the importance and the legitimacy of the presidential power to make appointments for lifetime judges and to stand accountable for it. And so, trying to comply with my brother Brennan's charge, I've been loud. At least 50% of his charge was honored. I urge you to think about a mandatory constitutional convention authorized by the 5th article for the purpose of taking a close look at the authority of the federal court. There are many ways to curtail federal court authority. The jurisdiction of the United States Supreme Court is properly a matter for the Congress of the United States. They've decided not to exercise any meaningful supervision over the jurisdiction of the United States Supreme Court. because the congressmen are perfectly happy to have the Supreme Court justices decide all the hot-button issues: political apportionment, abortion, marriage laws, declaring that sodomy is protected by the United States Constitution, and all the other highly charged, culturally important issues that the Congress should have been addressing. And in my view, and the United States Supreme Court has undertaken to decide without any constitutional warrant at all. I may be wrong about that, but an Article 5 amendatory Constitution could explore that proposition. Thank you very much.